Welcome to Reopening Connecticut Arts Venues Science-Based Safety. I'm Eric Dillner, the CEO of the Shoreline Arts Alliance and the chair of this task force. The mission of our task force is to offer you the opportunity to reopen your arts venues from a public health perspective, provide a listening and sharing platform, and help build consumer confidence through science. Our goal is to offer clarity, practical advice, and an opportunity to ask questions related to your own risk reduction strategies. To date, our webinars have reached over 11,000 viewers in over 15 states and 4 countries. We are so thankful for the Emily Hall Tremaine Foundation and the Community Foundation of Middlesex County for stepping up as major partners, along with our chief partner and star of the show, Yale School of Public Health. What a tremendous gift you all are giving the arts community at large. As you can imagine, the Shoreline Arts Alliance Board of Directors have personally dug extremely deep to financially launch this project. And I just want to publicly thank the Shoreline Arts Alliance Board for their extraordinary leadership. We encourage everyone to attend each of our webinars and follow Shoreline Arts Alliance's YouTube channel and Facebook for additional information. You may also find many resources at www.shorelinearts.org. We, of course, want you to feel free to share this information broadly with all your colleagues. Today, we will help you dive deeper into your own process and help you explore legal considerations for the arts in a COVID world. We will offer you, as a teaching artist, employer, or arts institution, how best to build a plan with and for your audience, staff, and artists. We will also help you to understand the essential elements needed for your plan and how this will best protect you, your employees, and your audience, and what legally you should consider or know as you make your strategic plan, ensuring success for long-term viability in the arts sector. I also want to express a special note of thanks today to Pro Bono Partnership and Priya Morgenstern for helping us connect with attorney Matt Miklave. Matt is a nationally recognized employment and labor and civil rights attorney with over 30 years of experience representing individuals, nonprofit organizations, and publicly traded and privately held businesses in all aspects of employment and civil rights matters, practicing in Connecticut and New York. Once again, I'm pleased to introduce to you my co-chair, Sten Vermund. Sten is the Dean of the Yale School of Public Health and holds the Anna M.R. Lauder Chair in Public Health, as well as a secondary appointment in pediatrics in the Yale School of Medicine. As an infectious disease epidemiologist, Sten's research pivoted quickly to focus on the COVID-19 emergency. Sten, would you frame today's discussion? Perhaps you could give us an update on the vaccine status and how we could continue to adjust our thought process and business practices based on vaccine rollout. Sten?
Thank you, Eric, and welcome to Matthew. We're very keen to hear what you have to say, so I'll keep my comments short. I also want to acknowledge my colleague, Crystal Pollitt, our environmental engineer, who's been so helpful to us. She's on the call as well as a resource person, and we may have questions for her later. We are in a different era now than the last time we spoke on a webinar. We're in the vaccine era. And vaccines were looking promising last year, as we discussed, but now they have had emergency use authorization from the FDA in the case of 2 highly innovative, highly successful messenger RNA type vaccines. We've never had mRNA vaccines before, so this is a scientific breakthrough as well as a COVID-19 breakthrough. And then we have other vaccines. The Johnson & Johnson is poised for emergency use authorization based on their favorable clinical trial results. And we expect that AstraZeneca, their product will be shortly in arrears. They'll probably come a month later. And then we will perhaps see a Sanofi product and a Novavax product also in the spring or the summer. So there are multiple vaccine candidates that will be available to the US and global community. And this changes the calculus for the arts because it may help us return consumer confidence, particularly to our older clients, our older attendees to our arts activities. they may feel more confident now about live events. And I know I will. And then we also have the prospect for our employees. So our artists themselves, our performers, our museum docents, and others. So we really are seeing a calculus in how we can start planning for live events again. Would I feel comfortable in a movie theater sitting next to someone instead of 6 feet away? I think I would if we start seeing viral incidence rates plummet because we achieve herd immunity in the United States. I mean, if we can get to 80% of Americans who are vaccinated, the modelers would predict that you will see a steady and semi-permanent decline in incidence, in new case rates for COVID. And sure, in the flu season, the winter flu season, you might see a little bit of an uptick, as we do with all the respiratory viruses. But because we have such broad coverage for vaccines, we may blunt substantially the burden. Coronavirus may look more like flu, where we can mitigate the problems of flu with widespread vaccination, and we can do the same for coronavirus. Lots of questions I can't answer and nobody can answer. How long will the duration of benefit be from coronavirus? We don't know. What is the exact point at which we achieve herd immunity, where the incidence rate starts declining, even though we are short of 100% coverage? We're not sure about that either. I've seen estimates as low as 60%. The ones that I think are more plausible are closer to 80%. But we don't need 99% of Americans vaccinated to solve the problem. If we get to 80%, you'll see the pandemic die out on its own. Now we've got to get vaccine to Europe and lower income countries, the Americas. I mean, to avoid continuous reinfusion of virus and maybe novel strains that escape the benefits of the existing vaccines, we need global control. And do we have the political will to help fund such an endeavor? I hope we do, because that's going to be an important issue. So those are a few quick thoughts. As you know, we've had a surge of coronavirus in the wintertime here in Connecticut and in our region, nationwide, in fact. We have coped better with it. Death rates have been lower. But having said that death rates are lower, the absolute number of deaths are higher because of the magnitude of the surge in this winter time period. So we've been facing 3,000 to 4,000 deaths every single day in the United States. Our situation not as dire in Connecticut. We've been a little more disciplined in the public health measures that we've been talking about on these webinars, and I think that we have benefited from that discipline. I don't mean to trivialize this. I can tell you I had 2 friends die of coronavirus just last week. One was a prominent physician scientist whom I've known for 30 years at Stanford University, and he was only in his late 60s. And I had a very dear friend who was one of the leading lights of medical research in Zimbabwe, and he died just last week. So even though things are a little more favorable in Connecticut than in other parts of the country and other parts of the world, we still face a very, very serious pandemic. The good news, the vaccine is here. The manufacturing capacity is rising as we speak. Strategies for getting more vaccine into more arms are being developed by the manufacturers, by the federal government, state governments, and we're hoping to continue 1.5 million vaccines every single day as long as Americans are willing to take it, so that we can try to restore some normality to our small businesses, to our economy, and to our arts.
Thank you, Sten. So sorry for your loss. I think we all feel the pain of this so through and through, all of us. I want to I guess what I want to make sure that we all know is that Sten and his team have given so much time and effort to try to help us get this information out. And I wonder if the arts community as a whole would start thinking about how we can help to message and get behind Sten and his group on that effort. So I put that out to us all. Let's find ways of promoting this vaccine so we can get folks going. Well, again, thanks, Sten, and great segue in here, Matt.
Yeah. Eric, I'm going to interrupt just for 1 minute. Yeah. What you said is more important than you may realize. I've been dealing with the HIV pandemic since it started. And it was when we had celebrity spokespersons that we saw a major uptick in HIV testing. And when we had Magic Johnson say, I got tested, I'm positive, and I am now on drugs that are saving my life. And we had Elizabeth Taylor, and we had Elton John. So the people in the arts community, with their influence at local levels, statewide levels, national levels, can be such wonderful spokespersons for public health. So I just wanted to reinforce that point that you made. Thanks.
Great. Well, we'll get on the bandwagon and start making something come forward here. Well, Matt Miklave, thanks again for being here. Let's get right into this great conversation you've prepared for us about legal consideration for the arts in this COVID world. Matt, welcome. I'll get your PowerPoint right up and ready for you.
Thank you very much, Eric. It's a pleasure to be here. I appreciate the opportunity to speak with you. And we're going to share something. There we go. Awesome. So thanks very much. This is our presentation, Legal Considerations for the Arts in a COVID-19 World. Let's just go to the first slide. We'll jump right into this. I'd like to remind folks that I'm not giving legal advice. This is not a protected attorney-client communication. So if you have recently robbed a bank, this is not the time to be talking about it in your chat box. It's not protected by the attorney-client privilege. My name and contact information is here. One of the things I want people to sort of take away from this is you're not alone. I mean, one of the great things about what the Shoreline Arts Alliance has been doing is to sort of unite people together to share information. This is happening across the country and certainly across the states of Connecticut and New York, where I regularly practice. So there are resources out there to get you the help you need. It may come in different forms, it may come in different issues, but I will urge you, if you have a legal question, reach out. We can help you find the resources one way or the other. So please don't be shy about getting answers to the questions that are unique to your organization. So let's go to the next slide, please, Eric. When the pandemic started, I sat back and I took a look at my experience as an attorney for as long as I've been doing this. And I tried to take away some lessons learned from prior situations. It's almost a cliche when we call the COVID-19 pandemic unprecedented. And I'm going to give you a little bit of a dissenter's view. I think it's unique in lots of circumstances, but we've gone through challenging times before. You know, we had a pandemic back in 1918. We survived that. We've had enormous disruptive cultural and political and military events in our country. We had the SARS and Ebola epidemics that challenged us, not nearly to the extent they have here. We had the California wildfires several years ago, which destroyed massive amounts of businesses and homes, disrupted the economy. The Boston Marathon bombing, where we shut down the city of Boston in literally 2 hours and everyone had to stay home, and Hurricane Katrina. You can count the number of disasters we've had to deal with, and we've managed all of them. They all gave us different life experiences, both for our businesses and our communities and our families. And so what I would suggest is we take a look at the things that we've had to do in the past to sort of figure out how we're going to tackle this in the future. One of the other lessons that I take from this is you will be judged in the future based on the perfect vision of 2020 hindsight. In other words, one of the troubling things that happens, it's just a human nature sort of thing, is that when you are held accountable or when you are judged based on your actions, people won't remember what we know today. They're going to apply whatever their current worldview is retroactively and hold you accountable for what you may not have known. So that tells me to counsel my clients not only to record what you did, but why you did it. So you can talk to government decision makers, talk to juries, talk to judges, talk to people that are holding you accountable, and have them try to remember what it's like. One of the great examples, and we'll talk about this a little bit more too, is mask wearing. I've lived through the mask wearing pandemic and the changing advice, where we had clients that received scientific advice from the CDC and others early on in the pandemic that frowned upon mask wearing, said it did no good, and that advice turned out to be wrong. Well-intentioned though it may have been, it wasn't completely accurate. We're going to know things a year from now or 2 years from now that we don't possibly know. And the third lesson I take from this is that science will prove what we now know probably is very little. The Game of Thrones, I'm a big Game of Thrones fan, and one of the lead characters was constantly told by his wilding girlfriend, "You know nothing, Jon Snow," because he had his own view of the world without the wisdom of some other science, some other approach to the world. And I think that's important for us to be humble about this as much as anything else. We don't know everything. We will learn so much more in 2 or 3 or more years than we know now. And we have to be realistic about that. Next slide, please, Eric. All right. So this is basically the presentation. I'm going to spend a few minutes talking about the performance plan, how the essential process that you have to go through. I'm going to talk about that as a process, not as a result, because it's an ongoing issue. Then we're going to talk about some of the essential elements of the plan. The third topic is how do we protect our employees, our vendors, and our performers while we go through this. And finally, what we can do to protect the public. Next. All right. I think it's really important that we have a plan before you do anything. Have a plan. I was a Boy Scout. My kids were all Boy Scouts. 2 of my sons are Eagle Scouts. One of the things we learned back in the day was poor planning ensures poor performance. You have to be prepared for the questions that are going to be presented to you and for the challenges you're going to face before they happen. You should be having a thoughtful discussion about how we're going to answer these questions when they come up. Don't do it on the fly. Think about that process. I believe, I call it reopening. It could be an ongoing committee, but it's a reopening, a group of people that get together to plan how you're going to do this. This is not a one-person band. I think it should be a committee. I think it should be somebody who knows your business and the economic realities of your business. I think it should be somebody with human resources background who knows your performers, know your employees, someone who understands the facilities, not someone who's responsible for it, but the person who actually knows how to work an HVAC system, knows where the electrical plugs are, knows where all the chairs are stored, knows that system. I think you need someone in IT to talk about the practical limitations. One of the things that you have to take into account is how often you're disinfecting things and doing things along those lines. A lot of IT equipment cannot be disinfected. You need to understand that before you go taking your keyboard and dipping it in water or some kind of solution. You need to understand what's going to happen to the equipment. We had a situation where one of our clients used biometric readers in order to record time. So an employee gave a thumbprint in order to clock in and clock out. You could not disinfect those biometric readers because it destroyed the sensor. So they had to deal with a very real problem in terms of how to protect their employees, and they needed someone from IT in order to help them work that out. So those are the kinds of things. And finally, you need somebody to think about security. And that's just unfortunate in this day and age. We have people that have been physically assaulted because they've been trying to enforce mask wearing. We've had some very unfortunate incidents, and some of them are on YouTube, of people becoming violent. You need to take into account those situations when you're dealing with the public. I strongly believe in having a written plan. I strongly believe that the committee should write down how you get from point A to point B, every single aspect of your performance, how people come in, where they sit down, what kind of ticketing you do, what kind of advertising do you do, how do you actually physically do all of that given the restrictions of COVID-19. I think a written plan is important, and once it's in writing, every member of the committee must independently review that plan and look for the loopholes, look for the problems, look for the issues you haven't thought about so that you can address them before it happens. This is all about pre-planning. A written plan is a starting point, but it's important to be flexible. I think you have to appoint a responsible individual, whether it's a volunteer or a board member or an employee. Someone's responsible for monitoring the guidance that are being put out by the governmental entities. In Connecticut, it's the DECD that's responsible for putting out the guidance. It is changed on a regular basis. You have to pay attention to the changes. They are not always obvious. They can be very subtle. Look, we're all just trying to deal with it. And when you take a look at the guidance for the arts community, some of it is inconsistent. So one of the things that I noticed last night is we are now in, I think it's the phase 2.1. So it's slightly more restrictive. That phase conflicts with the written guidance that the DECD put out for the arts community. There are little subtle differences, but you need to be aware of them, and you need to be able to respond to them accordingly. All right, Eric, next slide, please. What are the essential elements of the plan? You need to think about each group of individuals that you come in contact with, because your duty to them under the law is different depending upon the nature of the relationship of the individual. And there are 4 groups that I think you're going to have most contact with. So a little law here for a second. In order to establish liability for an employer or an entity to have engaged in wrongdoing, you generally have to prove 4 elements: that the entity had a legal duty, that there was a breach of that legal duty, that there was because of that breach, what we call causation, an individual has damaged. You need all 4 elements in order to successfully sue somebody, virtually for anything. But the legal duties are what I'm focusing on here right now. And the duty you owe employees is different from the duty you owe performers if they're independent contractors, or vendors that are on your premises, or the public at large. So you need to keep in mind that. The duty to employees is governed by workers' compensation and occupational safety and health administration. And let's just talk about OSHA for a moment. OSHA just put out guidance on the 29th of January. It's new guidance under the Biden administration. We'll talk about a little bit about that more in just a second. But generally, If you have a workplace exposure to an employee of COVID-19 that results in hospitalization or death, it is a reportable incident. If the individual passes from COVID-19 and it's a possible workplace exposure, you have to report that to OSHA within 8 hours of the event. Well, let's just think about this. You might not even know about it when it happens, but you have an 8-hour reporting obligation. If it results in a hospitalization for an individual, or an amputation, or the loss of a limb, or the loss of an eye, that is reportable within 24 hours. And it is a fine if you don't report it. So you need to understand what the status of your employees is, what is going on. There is a presumption that a COVID-19 exposure is likely workplace based unless you conduct an investigation and you disprove that. You have to have a good faith basis for that. So that's telling you that you have a higher duty to your employees than you generally have to other folks. When we talk about performers and vendors in the public, those individuals, we refer to them as invitees. These are people that come onto your premises. And generally for these individuals, you have a duty to disclose what's called latent defects in your facility. So if you have had a COVID-19 exposure, if you have a concern of COVID-19 contamination, it is not sufficient for you to simply disinfect and not advise people about it. You may have a duty to do something more, like actively warn individuals before they come on the scene of the potential exposure. So these are all very tricky legal issues. You need to seek legal counsel to help you to work those out. You have an obligation to these invitees to provide a reasonably safe environment. You can't leave cords out. You can't have defective equipment. You can't have COVID-19 spreading through the air. You need to have a reasonably safe environment. Next slide, please.
Actually, Matt, before we move to the next slide, can
Sure.
I invite Frank Tavera from Palace Theater in Waterbury to ask you a follow-up?
Yeah, thanks, Eric. Thanks, Matthew. This is incredibly helpful. A lot of this has been discussed since the onset of this, the crisis, about, again, being a venue with patrons, having patrons sign off on some level of a waiver, have them click on something on a website says, I understand I'm attending your event and I will not hold you liable. Putting something on the back of a ticket that clearly states that the venue is not in some way, shape, or form responsible and or liable. What is the true legal, what is the legal truth on what would be best to serve not only the patron, but also to protect the venue in those circumstances?
So it's going to depend on the facts and circumstances of every particular matter. And we have a slide on this in a little bit, but I'll just cut to the chase right now. So for example, every person who's had a child go to school and had a field trip has signed one of those forms allowing them to go that contains some waiver language, right? But that doesn't mean it's open season on little Johnny or little Janie when Miss Ratchet finally gets the opportunity to get that little son of a gun or son of a girl, alone. It's not open season. So it may prevent liability in some cases, but it won't prevent liability for what we call intentional torts or willful, wanton, and reckless conduct. And what we're seeing in the litigation now, because there are so many lawsuits as a result of COVID-19 workplace exposure, they are working their way through the systems. Those cases are usually framed in the context of an employer's or a company or a landlord's willful, wanton, and reckless conduct, or reckless indifference to protecting the public. So I wouldn't go to the bank on having a waiver. I think they're good. I think they can be effective in certain circumstances. I think the bigger challenge that you need to understand is that you may not have insurance coverage for these claims. Most insurance coverages will disclaim coverage for COVID-19. And what that means is you may ultimately win the lawsuit for lots of technical reasons, either a waiver or causation or something else, but you'll be responsible for the legal defense costs of that lawsuit. That's just something that we have to deal with. So I wouldn't bet the ranch on having a waiver. That being said, every sports stadium in America on the back of that ticket has a waiver built into it. And I think they find that reasonably helpful.
So Matt, we have another question that just came in that asks, how can we know where the employee contracted the virus? How do we know it occurred at our location, or if it occurred somewhere else the employee has been?
Well, this is where the states are helping you prove that. One of the things that you have to do as part of your reopening plans or part of your performance plans is you have to make sure that you're keeping a log of who's in the facility and when they are. And if there's only one person that has COVID, that can help you prove they didn't get it at work. But if you have multiple people, if there's a cluster of folks that are in your workplace that develop COVID, then you need to think seriously about whether this is recordable on your OSHA 300 form, and you all should have an OSHA 300 form. And if you don't, you need to talk to somebody about that. Is it recordable and is it reportable? Those are two separate issues. It's recordable if it's a workplace exposure that results in some occupational injury. It's reportable if it results in hospitalization or death. Once it's reportable, that will lead almost immediately to a workplace investigation where the OSHA folk come in either in person or remotely in order to conduct a detailed investigation. So you need to be considering of that. But you in this environment, you cannot assume it's not a workplace exposure. You need to conduct an investigation to determine whether it could potentially be a workplace exposure or not.
Okay, and not to slow you down, but just tell us, employees, volunteers in this business are treated often like employees. Do they fall in the same guys here?
Well, if they are true volunteers, and we're not talking about employees, then they are what I called invitees, and your duty does not extend to them the same way it extends to employees. But I will tell you, there's a lot of litigation over employee status, who's an employee, who's an independent contractor, and who's a volunteer.
Okay, great. We'll let you move on to the next slide.
Great. Awesome. Next slide. The essential elements of a plan. You need to, and I think we've talked about all of these in the past, your physical distancing, your masks. What are you going to do about dissenters? What are you going to do about waivers and handling those people who refuse to sign a waiver, or handling those people who refuse to wear a mask? Now, one of the interesting things in the Connecticut plans are that the Connecticut plans say that any patron who refuses to wear a mask, you can deny them access. But the guidance also says that you should be wearing a mask unless you have a health condition that prevents you from wearing a mask. Employees are different. Those guidance suggests, it doesn't state, it suggests that an employee who has a health condition that prevents mask wearing need not wear a mask provided they give medical evidence of their health condition. So this is going to be a little bit of a challenge for us. And you're going to have to think about what you're going to do in those circumstances. How are you going to enforce your mask mandate? Who's going to be responsible for it? You don't want to address that issue the first time 5 loud patrons show up and refuse to wear a mask, like the Trump folks at the debate, and they're just going to sit over in their own little corner contaminating everybody. That shouldn't be the time you're thinking about how to address it. You need to think about how you're going to do that. And what about the employee who cannot wear a mask? Do you want to give that individual carte blanche to walk around advertising that they're not wearing a mask? How does the coworker know that person has a medical reason for not wearing a mask or not? These are really tough questions. On the other hand, you don't want your coworkers walking up to the person that has a medical condition that they can't wear a mask because of that and going, hey, why aren't you wearing a mask? And being bullying and confrontational, because that can lead you to a harassment claim. You need to think about how you're going to handle these problems before they come up. And they may only come up once in a blue moon, but when they do come up, it's a particularly big problem. We've talked about waivers, and we've talked about a little bit about the vaccines. Now that we have vaccines available, there's going to be a big challenge to us over how we're going to handle vaccinations of our employees, our performers, and our patrons. What are we going to require folks to do? We've got some other elements on the vaccines that I'll get to in just a minute. So let's move to the next slide.
Matthew, can I go back one step, please,
Sure,
if you don't
please.
mind? Coincidentally, I did have a call last week, from a patron of ours at the Palace Theater who has a medical reason not to wear a mask. She's very clear about it, and she was also very accommodating to say she would come early, she would sit in a separate section, et cetera, et cetera. But she wanted to know what our policy was going to be. I had told her that we had yet to confirm that because we're still in the process of we'll say making soup at this point. But is there going to be any kind of situation or rights infringement if we say, yes, you can come, but you have to sit in a separate section, or you need to be segregated from others? I mean, I'm sure there's going to be a host of situations on a case-by-case basis, but what is kind of like the global response to venues like ours who will welcome people, who may welcome people who have a medical condition, but how do we treat them, and how do we make sure we're not treating them in a discriminatory fashion as well?
I think that's a great question, and I think that kind of highlights one of the challenges that we have, because if you are barring people with medical conditions from entering your premises, and your premises is a place of a public accommodation, this could be a problem under the Americans with Disabilities Act and under Connecticut and New York state law, depending on your states where you're located. So that's why you need to get legal advice about that. I think you need to think about it. I think it's a terribly difficult question. The flip side is, are you going to be segregating people with disabilities into particular areas? We went through this litigation in the 1990s where people with physical disabilities were filing lawsuits complaining that they were relegated to one section of the stadium or one area for the performances. And they were insisting on being able to get different areas with different views and different price points. It's a very difficult problem to deal with. And there is not one size fits all. One of the difficulties we have with it as well is it's going to vary by state law as well. You may have, people with disabilities may have more rights under state law than they have under federal law, at least until the Biden administration took over. So that's one of the challenges. So I do think it's a thoughtful discussion that your organization has to have. There's obviously a public relations component to this. There's an accessibility component to this. There is how that decision fits with your organization's public perception, how you want to be perceived by the public. We could spend an entire session just talking about that issue alone.
So just to keep you going there, we have a question that came in from based on an employee. If they medically can't wear a mask, can you mandate remote work only? And if remote working is not possible, can you separate because the patron contract is a requirement of the job?
Yeah, I would get legal advice about that very specific issue. I would be concerned if you had decided that mask wearing is required at all times and there was nothing else you can do and you ended up separating that individual employee. And the same goes for vaccinations as well. Whether an employee is unable or unwilling to take a vaccination, is that going to be the determination for employment or not? There is guidance out there. And I'll talk about it in just a minute. I think we have an entire slide on the vaccination issue. There's guidance out there, but I have reason to question whether it's terribly accurate. Okay. All the words are staged, but yours is not that big, right? 6 feet separation. You've got a bunch of woodwinds or a bunch of singers. How are you going to get them all staged? You got to figure that out. It's really hard, right? There's special problem with singers. Contactless ticketing. How are you going to handle people getting in or out? I think there are a lot of apps that are available now. What are you going to do about programs, about recycling programs? Because that's where you're getting a lot of revenue from advertising, but you can't really recycle them. You can't reuse them from concert to concert. How are you going to handle that? Disinfecting between performances. I think Erica said you had a special session talking about the disinfecting and the cleaning protocols. They can be very complicated without any question whatsoever. We've seen just how difficult these practical issues are. Understand that the DECD, no matter how much they're trying to help, right? They're not living in your world, and some of the guidance has to change over time as they realize the practical problems that you're facing. A word about masks. We've all lived through the mask contamination problem. Masks were no good at one point in time. Now don't use them. Now everyone's supposed to use them. I actually came across a really great NPR story from August of 2020 talking about the Gator Gate. Is a gator one of those things you pull up over your face? Is that really a mask? Does that really count? Not all masks are equal, according to at least the recent studies. So you need to think about what you're going to allow in your workplace. One of the issues several of my clients have had are masks with messages. So the face mask that's a surgical N95 mask, do you want it to say Black Lives Matter or Stop the Steal, right? Those create issues of political speech. How do you want to handle those issues? They're very complicated. What about your patrons who come with their homemade mask that's just nothing but a loose leaf mesh that really isn't a mask, or you don't think it's a mask? What are you going to do about those issues? You need to think about them. We talked about underlying medical conditions, and how do you handle the people that refuse? Do you empower your coworkers to confront them, to put social pressure on them or not? If the individual has a medical reason for not wearing a mask and they are constantly being hounded by coworkers about their mask wearing habits, that could be an issue. I know in my household, at least, there were a lot of comments about the inauguration where a lot of the guys that were up on stage were wearing the mask below the nose, which seemed to be counterintuitive, didn't really do a lot of help. And whether that's just a man thing or whether it's more difficult than that. Next slide, please.
So we actually have I think we can, John Carl Casa, CEO of the Connecticut Nonprofit Alliance, has a question about surveying employees. John Carl?
Yeah. Is it possible to, well, two questions really. One of them is whether there's a difference in how you treat employees, whether they are unable and unwilling or unwilling to wear a mask. If someone's unwilling without having a valid medical reason, how do you treat that situation? But the other situation is, can you basically require employees to stay at home when they're not at work? Sort of good conduct in order to work. Can they, do they have to stay home, or can they travel out of state or encounter other people, et cetera?
Yeah, great questions. Really great questions. We've struggled with these throughout the course of the pandemic. Every employer has their own rules and regulations. A lot of employers were, based on advice of counsel, were doing questionnaires, daily questionnaires, and some of those questions were, have you been socially distanced when you have been out in the community? Have you been socially distancing? We unfortunately had some experiences where employees would complete that survey and say, yeah, they have been, only to look at their Facebook photos with them at the beach, crammed together like a bunch of sardines. Each employer needs to make their own determination. Now, I do believe the current state of the law would support an employer refusing to allow an employee to work if they're not maintaining social distancing and following the protocols because of their own personal beliefs, as opposed to medical conditions or religious beliefs. And that's because federal law gives special rights to people who are exercising their religious beliefs, sincerely held religious beliefs, or their ADA rights, Americans with Disabilities. We see this in a lot of cases. And we'll talk about this a little bit more in I think it's the next slide. So maybe we can go to that one, because I think we talked about waivers.
Yeah, next one.
Yeah. Okay. So let's talk about, and this is going to be about vaccination as well as mask wearing. So the current EEOC guidance, which came out in December, says that an employer can mandate an employee to get vaccinated, and if they refuse to get vaccinated, you can separate them from employment, that vaccination can be an essential function of the position. That is during the period of the pandemic only. There are special rules that kicked in, public health rules, as a result of the pandemic. I will note for you that was one of the last acts by the EEOC under the Trump administration. So I have no idea what the Biden administration is going to do with that guidance. I will tell you that in other contexts, when we were dealing with a requirement for hospital workers or schools, for those employees to be vaccinated against the flu, employees that were unable to get vaccinated because of a medical disability, allergy to eggs, because many flu vaccines are made of egg-based products, and so a whole segment of the population can't take them, or for sincerely held religious reasons, the employers were found to have violated the law when they separated those employees. The court ruled that they had to engage in an interactive process. That is a give and take to see whether there's any way that those employees can be accommodated. There are a couple of cases that have held that an employer could terminate those employees because their refusal or failure to take a flu vaccine amounted to them being a direct threat to the public, that their potentially giving flu to children or to patients was a direct threat, and therefore they could be separated from employment. The problem I have with that is that we have been dealing with employees who have not been vaccinated, interacting with the public for the last 10 months. And by the time, everyone gets vaccinated, the last year or more. And we haven't found them to be a direct threat to the public. That's why I'm skeptical about the guidance. And I'm skeptical about the guidance about masks as well. So generally, if an employee is refusing to wear a mask or refusing to get a vaccine for their own personal reasons, unrelated to medical conditions or religious beliefs, you do not have to accommodate them under current law. If they have a medical reason or they have a disability that prevents them from being able to either take the vaccine or wear the mask, then you may have an obligation to reasonably accommodate them. If they're simply engaging in dangerous behaviors, there is no duty to accommodate that at this point in time. Okay. Let's make this a little bit more complicated. Two other things I wanted to note. The new OSHA guidance that came out on January 29th said that employers should get their employees vaccinated at the employer's cost. The vaccination should not cost the employee any money. And they should not differentiate between employees who do get vaccinated and those that do not. So this is OSHA guidance. It doesn't have the operation of law, but it's one of the things I look at when I'm suggesting that the federal government, this change in administration, may be changing the guidance as well, and you need to think about it. Footnote here as well, local law is very different. In New York City, for example, they have a very robust civil rights statute, so it really does depend on local law as much as anything else. Next slide. I'd like you all to remember all of this information: who has a medical disability and they can't wear a mask, whether they've been vaccinated, if you're requiring employees to take their temperatures or you take the employee's temperature. All of that information are medical records that cannot be disclosed to the public, right? They have to be maintained in a separate, secure file, accessible only to those who have a need to know. What about your patrons? They want to make sure, you may come upon the time when they'll want to make sure that all of your employees have been vaccinated. You cannot tell them that. You cannot disclose to your patrons who has a medical condition that prevents them from wearing a mask, who's been vaccinated and who hasn't been vaccinated. So that is really a problem. And let me share just how schizophrenic this is. The EEOC came out with guidance last year that stated an employer can provide economic incentives to employees to engage in healthcare practices that are beneficial. But they said the incentive can't be so extreme as to make the participation in that program involuntary. In other words, if you're going to give someone thousands of dollars in order to get a vaccine, that's probably prohibited by Title VII. But if you're just giving them a couple of $100 or a gift card to Starbucks or something, that probably is okay. So this is all very controversial and it's evolving very rapidly. Next slide.
Actually, we have a question from Judy Dwarwin of the Judy Dwarwin Dance Project. Judy?
Just something where a landlord in a situation is sharing a space and wants to mandate proof of vaccination in order to be able to be in the space, or they want to ban any employee who can't show proof.
Yeah, I think that requires a discussion with the landlord. I'm not sure that I would be comfortable advising my client to comply with that obligation, because I don't think it can be done. The other thing that's kind of here, and I got a slide on this in just a second too. Remember here we go. No, that's okay, Eric. Remember the vaccination, even at the best of all possible worlds, it's only 95% effective. Now I say 95% effective because the flu vaccine is a lot less effective than that, and we all get a flu vaccination every year. But at 95%, it means 5% of the people who get the vaccine can still get COVID. And we don't know whether they can be a carrier of COVID or not. So I think we're relying a little bit too much on the vaccinations right now. It's a good thing. It's a great development. I'm very encouraged about it. I hope to get my vaccine any day now. As soon as they let me, I'm in line. But what are we going to do about that? I mentioned here Health Pass because this is that app that's on the phone. A lot of people are talking about an app the Health Pass that records whether you've been vaccinated or not, that you can use that in order to get on the plane, in order to go to a foreign country, in order to get to work. I don't know. First of all, it's an app. What could possibly go wrong with an app? I have no idea. I don't know you, right? Right. It's a disaster waiting for happening. Secondly, it's publicly available health information. I don't know how we mandate the use of Health Pass. I think we're going to hear a lot more about this in the coming days and weeks. Next. All right. So I was told you have to end every presentation with a good quote. Lincoln's one of my top 10. So there you go. We are in a new era. We're going to be doing this for a long time. We're all in this together. I think we're just sort of focused. We got to focus on doing the best we can and muddling things through. And I'm happy to answer questions. Any more questions folks have?
We have a question from Judith McElhorn from the 5 Point Center of Visual Arts. Judith? Did I lose her? Looks like we're having hi, Judith.
Hi, I have very unstable internet. I want to thank you so much, Matthew, for all the information that you're giving. So let me be clear. What you're saying is we need to plan very carefully. We're just opening a new art center and planning for when that might happen. All the information you've given has been very helpful for us, but I think the thing that stuck in my mind most was record keeping. And you do emphasize that that's very important as we plan. Is that correct?
Well, I think it is. Remember, in Connecticut, you have sector guidance. The sector guidance is very specific. One of the things you must do under the sector guidance is you must keep logs of who is in your facility and the occupational amount that's in your facility. That's required. One of the other things you have to do is give a copy of that sector guidance to every one of your employees. That's a mandate. If you do not do that, you cannot self-certify that you may open your facility. So record keeping is really important. This all comes together to help, I think, you as an organization. If you do have an outbreak, it can help contact trace. If you do have somebody that comes down with COVID-19, it can help you prove it wasn't a workplace exposure. So I do think planning is essential for lots of different reasons. And again, I'm a big believer in having that team approach and making sure you think it through. Literally, when I talk to clients about their plans for operation, we literally figure out how the employee gets from their home to work. Do they take public transportation? What kind of public transportation do they take? Are they on a bus? Are they on Metro North? Do they drive themselves? Where do they park? How do they get from the parking lot into the building? Which doors do they use? We literally walk through the entire process from getting to home to getting back to home that night, so we can identify places where we need to intervene. This has led many employers to prohibit employees from taking public transportation in order to come to work. This has enormous impacts on the people of lower economic status. So that's why we have to think carefully about these issues. And it's not going to be the same answer for everyone. Your organization is going to have a risk tolerance and a public perception and a PR approach that may be different from another organization.
Matt, I'm going to see if Sten has stepped off. Or Sten, are you still with us? We have a question for you. If he's still with us. I know our time has passed.
I'm here.
Okay, what do you think the timeline will be on a less expensive rapid test? And do you see them playing a role at venues as we open back up? Will you be able to require it to be taken as a requirement of entry? So maybe you can address the timeline for the less expensive rapid tests.
We already have rapid tests. Their cost is not favorable, but there's no technical reason why costs can't be driven down. We're hoping that marketplace forces will drive costs down. As it stands now, there's so much demand and so little supply that costs are still high. But the natural evolution, I think, over the next months will be that costs will drop, and there's a lot of competition in the marketplace now for rapid tests. Now, keep in mind that rapid tests are looking for the antigen. They're not looking for the genetic material. Looking for the genetic material, like the PCR, is more sensitive. Looking for the protein is less sensitive. So the rapid tests are a little less sensitive, but at least a rapid test can tell you if you're highly infectious, because we do think that if you're negative on a rapid test, an antigen test, but positive on a PCR, you are probably with a lower viral load. That's why you tested negative on the rapid test, and you are less infectious. So it still can be, the rapid antigen tests can still be a tool, I think, in public health practice to at least weed out highly infectious individuals. I hope that wasn't too confusing.
No, thank you. That's very helpful. John Carl, you have a question.
Yeah, it actually kind of flips around on some of the issues that you've raised. I mean, if you're an employer or a venue and you don't do some of the things, you don't say enforce mask wearing as stringently as you might, for instance, and people become sick, is there a liability problem that you're facing? Or even less dramatically, if you make people come back to work and they work in a workplace where maybe the ventilation system, you might not even be the landlord, the ventilation system isn't that great and people get sick. As the employer, you have liability?
So let me answer that in two ways. First, let's talk about the employees first. Workplace accidents, including workplace exposures to COVID-19, are likely covered by workers' compensation. In Connecticut, there is a presumption that a COVID-19 exposure is a workplace exposure, and therefore workers' compensation benefits are available. If workers' compensation is available, there is no lawsuit that can be brought unless the employer's conduct has been willful, wanton, or reckless. And that's where failure to abide by the reopening guidance, which is mandatory, is evidence of a willful, wanton, and reckless conduct. Remember, you have to certify to the state of Connecticut that you are in compliance with the reopening guidance in order to lawfully reopen. If you do not complete that certification, you can lose your license to do business permanently in Connecticut. So they can put you out of business. And there have been businesses that have been put out of business because they have not been in compliance with the reopening guidance. So that's why it's so important to do that. I also think the same is true for lawsuits by the public. Those lawsuits can be brought if you have been negligent or grossly negligent. Failure to comply with sector guidance could be evidence of gross negligence. And remember as well, you likely have no insurance coverage for those claims. So that means now, of course, the problem is the plaintiff in those cases would have to prove that they got the exposure from your facility, which is also going back to, the logs of how many exposures were there, how many people got sick. So that's sort of the challenge we see. We see this in mass tort cases a lot, where you have a fair or an event where there's lots of food carts and there's 20 people come down with food poisoning, and they're able to piece it together and track it to the particular food cart that everybody had in common. That's sort of the same thing that goes on with COVID-19. That's why contact tracing is so important from the public health standpoint, to determine the source of the infection, to eliminate the source of the infection, but then the lawsuits come after that to hold those people accountable.
Well, Matthew, we've got a ton of questions coming in, of course, at the last minute here, which I know we'd love to answer them all, but I think we've already passed our time limit. I want to thank you. Actually, I just realized I didn't put up. This is Matthew. For any of you who need a little extra help, feel free to contact him. I also want to quickly introduce Priya Morgenstern from the Pro Bono Partners. Priya, can you pop on the screen and say hello for a minute? Thank you again for hooking us up with Matthew. Your service to the nonprofit sector is just huge. Thank you.
I want to thank Matt for an awesome presentation and let you all know that you're really, you heard it from one of the best, and the Pro Bono Partnership, in fact, has decided to recognize Matt for his extraordinary contributions to our work supporting the community in terms of COVID-related presentations of this kind. He's going to be receiving an award from us this year. Matt, I hope it's okay that I told everybody that.
Well, thank you. I as I said last time we spoke, it's undeserved, but I'm not giving it back.
All right, good.
That's wonderful. Great news all around. Absolutely. Well, Sten, Crystal, I appreciate you being here today. We didn't tap into your resources, but we will in the coming days. And Sten, thank you again for all you do. We're going to be heading out on the road again with some site visits coming up soon. You may have seen in the slides, if you caught them, you would want to contact communications@shorelinearts.org if you're interested in a site visit. And again, on behalf of Shoreline Arts Alliance, the task force of Reopen Connecticut Arts Venues, and the rest of us all here, thank you all so much. Have a wonderful day. If you didn't catch the whole webinar, because we had a little bit of sound issues at the beginning, it'll be on YouTube in a few days on the Shoreline Arts Alliance site. So again, thank you all so much and have a super day. Take care.
Thank you.
Bye-bye.